a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
And here he is, David Whiting, well-known Melbourne solicitor who's advising you on your legal challenges. David, good morning.
Good morning, Virginia.
Got any homework for us today?
No homework, but absolutely case, the law of unintended consequences.
Yeah.
It's an American case, and there's an action being run by an insurance company. The circumstances are that a couple were being intimate on the back seat of a motor vehicle. She obtained or got a sexually transmitted disease.
Oh, I heard about this one. Yes, go on.
She made a claim against him for damages as a consequence of
contracting the
disease, and he made a claim on his insurance company, and the insurance company said, go away, no claim. Now, what then happened was that instead of issuing proceedings, there's a process for having an arbitration, so a private judge, which you can then register as a judgment. The private judge awarded $5.2 million to the woman concerned. That's now been registered as a judgment in the US, and the insurance company is now saying, no, I need to get this set aside. It shouldn't have been admitted. Now, to read the insurance policy, it says that if you suffer a disability or a sickness as a consequence of the use of a motor vehicle, you're entitled to make a claim on the insurance policy. So it's really a question of the insurance company could have stepped in and said, no, we're defending this claim.
Yes.
They chose in that point to ignore the claim, and now there's this judgment. We're finding by a judge.
Which they could appeal, I guess.
They're endeavouring to get the judgment set aside, but then there's a state court issue and a federal court issue, but it truly totally unintended consequences from the insurance company's point of view. Here's something that they hadn't considered might be covered, and the question will be, will there be more of those cases? Let's hope not.
Well, yes.
Yeah.
That's extraordinary. How clever of the woman's lawyers to go down that route.
Yes, we haven't got any money yet. Let's wait and see where it ends up.
You reckon it'll end up with a payout?
Well, there'll certainly be a nice cost element to it, yes.
My goodness me. Well, over to you. I don't know if you've got a problem as curious as that one, but anyway, if it's for air, go right ahead. 1300 222 774 is the number. And David is happy to hear from you. Naomi in Emerald, go right ahead. Good morning.
Hi, how you going?
Good, go ahead.
I got a building job done after a tree fell on my house probably about 6 months ago.
Yes.
And the carpenter that did the job, he's a registered builder, he got his own plumbers and that to do
so he managed
he
managed the work that needed to be done. Yes.
Yeah, he managed the work that needed to be done. And yeah, look, they rebuilt the deck and they sort of reused all the old materials and that sort of thing because it was going to be more inexpensive. So at the end of the job, I think what had happened was that I noticed that the plumbers that they got they were really, really young. And
can we cut to what's the question, Naomi?
Oh, the question is basically now that it's finished, there's lots of things that are wrong with the job, and in particular the plumbing job. And they
so,
haven't
Naomi,
come back
my question of you is this: did the builder engage the plumber, or did the builder introduce you to the plumber?
No, they engaged the plumber. I had nothing to do with engaging the plumber.
So who did you pay, the builder or the plumber?
The builder, yeah, the builder.
Okay, then you have an action against the builder.
Yeah, but they won't get back to me.
Then you can talk to the Victorian Building Authority or you can issue a claim in VCAT. There's a process you need to follow first. It's the Domestic Building Dispute Resolution process. So there needs to be a discussion with the builder, a mediation that's conducted with a view to receiving it's capable of being resolved, and if not, you go to VCAT.
Good luck. We hope that's helpful. Marianne in Bentley, good morning. Go ahead.
Hello, good morning, David and Virginia. Thank you for taking my call.
That's all right.
I'm ringing on behalf of my partner who loaned his son some money and he refused to give the money back. Now we need to do quite a lot of renovation in a house.
Marianne, how long ago was the money lent?
Oh, about 5 years ago.
Okay, and is there...
Because he had a lot of debt, the son,
Yes.
so he put the money in for him to... so he won't have to pay so much interest. And the understanding was that when he needs the money will be returned.
So, Marianne, I have a slight problem there. What the understanding was or what the deal was?
The deal was...
Okay, the deal was that the money would be repaid, but let me ask, how much is involved?
Oh, it's about $35,000.
Right,
And,
if he didn't have $35,000 6 years ago, why do you think he's got it now?
Who?
The son.
Oh, because he loaned him the money.
No, I understand the money went, but the money went to pay other debts.
No. It wasn't the case. It was like he loaned him the money because the son had a huge mortgage, so he was trying to help him with the understanding when he needs the money, like for renovation, etc., the money will be returned. But the money has never returned. He's been asking for the money.
Your only option is to sue him.
Uh-huh.
There's no VCAT. It's a magistrate's court matter to sue for the loan to be repaid.
I just wanted to know, is there a possibility that because he's going to leave the estate, the unit, to his two children, now is it possible for him to take a loan from the bank on the proviso that, withdraw the money?
Yes, you can adjust it you could adjust the loan in your partner's will. So to the extent it's not repaid, then it bears interest. Your problem's going to be that your partner may have difficulty in borrowing the money in this day and age to do the renovation, but it would be possible to adjust for his non-payment in the will.
Yeah, that's what I mean. There is a loan for pensioners whereby you...
like an equity release loan, yes.
That's right.
So, Marianne, what you do is you'd put a clause in the will that says, on this day I lent this amount of money, and you could even, if you like, tie it to the amount of the money under the equity release loan. Mm-hmm. They come along and say, well, out of his share comes the mortgage.
Yep. Thank you for that.
Thanks, Marianne.
Good luck, Marianne. It sounds like a tricky situation to be in family-wise. Mary in St Kilda. Mary, go ahead.
Hi, David. I'm a shareholder in a company share apartment title property, and we have, on the title for our property, we have two lots. One is lot 1, which is the main property with the apartments on it, and one is lot 2, which is 2 laneways at the back of our property. And we've been paying rates on those 2 lots, and they're included on our title. But now the council says it's their laneway, and we don't own it.
And what do you want to do?
And I've said to the council that I believe that we own it, and it's not their laneway. And they've recently repaved it without seeking our permission, and said, well, we've spent, $100,000 putting new paving in the laneway, and that's our laneway now.
The doing of works on private property doesn't mean they now own the laneway. I think, Mary, what you and the other people in the company share flat need to do is engage somebody to look at the plan and be absolutely satisfied that it belongs to you as the owner. There's also the council will keep an assets register, which you should be able to look at. So St Kilda would be Port Phillip Council. You can have a look at their website and you'll see whether they have included that in their assets register, and you can get it fixed. If you can't get the satisfaction you want, then go to the Ombudsman, but you need to get some advice of someone looking at the title and giving you an opinion that starts your argument with council.
They have included it on their assets register.
Yes.
And we believe wrongly, and we're still paying rates on that land have been ever since the title began and still are up to this
Still
year.
the same argument, Mary. You've got to prove them wrong. Or I don't want you to go to court for a declaration that they don't own the laneway unless that's the position that everybody wants. If you think they're wrong and you can put together a submission, go to the Ombudsman's office and say, they've wrongly taken my land.
Okay.
Thank you.
And which Ombudsman is that, David?
The Victorian State Ombudsman has the right to investigate councils.
Mary, hope that's helpful. Thanks so much. Carol in Bendigo, go ahead.
Hello.
Go ahead, Carol, you're on the air.
Oh, hi, David. David, I had my car at a mechanic's in 2017 and they couldn't fix my car, so I took it from them. Now, I probably was getting a bill sent to me once a year, and now I've just received a letter from a debt collector, and I'm just wondering what I'm supposed to do.
It's a question of what was the deal that you struck in 2017. If you, in 2017, so you go and see a mechanic, are you paying the mechanic for trying or for solving? Because every now and then we all get some work done which doesn't quite work out as intended. It doesn't mean we don't owe the money.
Right, that was to solve the problem.
Well, that's what you went for. It doesn't automatically follow that that's what the deal was. So that's really what it comes down to. Was the deal I'm only going to pay you if you can give me a concluded position, or was your deal I want you to work on my car and try and fix it?
Oh. Well, I can't remember what the actual deal was.
Should the matter go to the Magistrates Court or to VCAT, that's the question.
Okay.
Now, you could respond to the debt collector and say, I was happy to pay had the job been completed to my satisfaction. It wasn't. He was unable to do it. He or she was unable to do it, so I took the vehicle back. But again, it will come down to what was the arrangement.
Patsy, is anything written down anywhere, maybe a text message or something from the mechanic saying, I couldn't fix it or I can't sort this, anything?
No, it was all verbal. And then I actually sent an email to him explaining why I wasn't going to pay for it, but they never responded to my email.
Oh, so you got that email written somewhere and dated?
I've lost the email. Unfortunately, I don't have the email.
That sounded like a good document. That's a good document.
That's been your position for the last 5 years and the mechanic's not done anything about it.
Yeah.
That would make your case stronger if you could find it, Carol.
All right, then. Thank you for your help.
Yep, try and find that email because that's a doozy.
Yes.
Let me tell you why I am not paying you.
Yes, because...
And if there's no response from the mechanic...
Well, it's again the argument. We still have the argument, but It's not like here it is 6 years later I'm now complaining.
Yeah, absolutely. Stephen in Sunbury. Go ahead, Stephen.
Hi, thanks. I love your show. Really appreciate this. I had just a little one. I got pretty sick last year and I had private health, but I had the gap for the doctor. So I sold some household windows and doors and that for $30,000 cash to a lady 18 months ago. But she hasn't picked them up. She's paid the money. I've tried everything to contact her. I can't get in contact with her. And the premises that I was living in, I have to move out of because of my health and I have to go back into hospital. So I don't know where I stand. And the person I've rented the house off, he said, no, I'm just going to throw this stuff in the bin. So it was 18 months ago. She paid the cash. I've tried every means. I can't find her number. I've tried Facebook and everything.
Yeah.
And I just don't know what to do. And I'm a bit frightened that if I leave this house and I have to go back to hospital, I've got a pretty serious illness, that, she comes back in years to come, things like that.
What you want to do is look at the Australian consumer law for the disposal of unclaimed goods.
Okay.
You were storing them from her as part of the sale process. She would come and pick them up. She hasn't come and picked them up. The Australian Consumer Law and Fair Trading Act has a process for unclaimed goods. Essentially, you advertise them, then you auction them, and then you send the money to unclaimed monies.
Oh, okay. All right.
Right, that gets the pressure off your back.
All right, then. Thank you very much for that.
Thank you, Steve.
And you've got to step through that process exactly as
yes, and at $30,000, they're high-value goods. There will be a process for advertising.
Yep.
And then there will be a process for an auction.
But you're not taking the money at the end of that auction.
At the end of the day, it goes to the State Revenue Office on behalf of the State of Victoria for unclaimed monies. But Stephen's big problem is going to be I don't know who it is, but what he might do is go to his bank and say there was a deposit of $30,000 into my bank account.
Track that back.
What I'd like you to do, I don't want you to tell me who it is, but go to the bank and say, I need to get in contact with the person who paid the money.
And deliver the goods.
Yes.
Or get them to collect the goods.
Yes.
Yeah. Wow. I hope something terrible didn't happen to said person. I mean, it's a bit of a mystery, isn't it?
$30,000 is a lot of windows.
Yeah, and you wouldn't have thought that someone would just disappear and not want to actually get them after paying that money for them.
No.
So I have a sinking feeling in my heart that and I hope not, that something bad hasn't happened to that person. Yeah.
Well, you would also think that the house that she was going to put the windows in would be at the point where the windows were needed by now.
Yeah. 1300 222 774. Guess what? Unusually, I have got 3 lines free for David Whiting, and that never happens, and 10 minutes to go. So you've got time to ask him a question if you would like. Janine in Rosebud, go ahead.
Oh, good morning. I've just got a query about an earthquake damage claim that I've made through my insurance company. I made a claim for some damage which was cracking to an internal wall, some corners, but mostly the flooring. I've had an offer of settlement from the insurance company which covers the wall cracking and the corners cracking, but they've said the floor cracking itself is due to a pre-existing condition, which I presume is because it was in an area where we added on, did an extension, so where the old and new house joined.
And do you accept that, Janine?
Well, I suppose I'm just confused in that to me the cracking was there. The cracking was there after the earthquake. There wasn't any cracking before, but they've sort of totally disregarded that. So I'm just not sure.
But if it's an extension, then what you've got is 2 separate buildings. Yes. Where the line at the point of construction is moved a little. Now that may not be covered by your insurance policy. It's a question of reading the terms carefully. Okay, so it's almost like a different situation for each different part of the house. Well, if you've had an extension added on, the level of integration may not be particularly great. It may simply be there are different sets of footings. Okay. But read your insurance policy and see how that works. Okie doke.
Good luck.
And talk to a builder. The builder will be able to tell you what whether they ought to be together. Now, look, I live in a wooden house. There's a little bit of movement in my place, so happens.
The degree that you have to expect. Also, depending on what the house is actually built on, we're built on clay.
Yes.
So as that dries out, there will always be a little bit of cracking and movement. Stefan in Phillip Island, go ahead.
Hi, I'm calling on behalf of my parents. They've just purchased an apartment and they're having some issues. So they purchased it, and in the Section 32 it states a series of defects. Now that's fine. They see that the body corporate is working through them. However, there's one that it states that there's some water egress in between some apartments. Now they're trying to move in, and the upstairs apartment on their property has it's created a huge water feature into their living room. Given the last couple of days of weather, they've got massive amounts of water now pooling in their apartment. The quantity is so much that the neighbour below them is now concerned that if my parents don't mitigate the water that's in their apartment, if it's going to start affecting them.
Yes.
They've tried to get in touch with the owner of the apartment. And at first she seemed pretty concerned about it, but she then palmed them off to her real estate agent because she's actually looking to sell. And he stated to them that, no, my parents are up for the costs entirely because it states that there's defects in the building, and if they want to basically replace the top floor, that the onus is entirely on them.
Stefan, it depends on where the water's coming from. Now, I know that the proximate cause of your parents' water damage is the apartment above.
Mm-hmm. Yep.
But the question will be, where's the water damage coming from above that, if anywhere? So I've had a couple in the last 6 months. Mm-hmm. One was where we were below someone else's balcony, and the water was coming through the balcony into the apartment. And I've had another one where it was coming from 2 apartments above. So Section 16 of the Water Act deals with unintended, what I'll call water leakage and unauthorised flow of water. It's a VCAT matter, and it involves the owner of the unit above, but you really need to be able to establish that that's where the water's coming from.
Yes, so they actually, after looking into the ceiling and seeing, trying to do some rudimentary inspection and having a roof plumber there, they actually believe that a waterproofing membrane is either not
at the bottom
there
of the shower
or, at least
or something
not
like
installed
that. The process is the same,
properly.
Stefan. The VCAT Water Act claim.
Okay. Peter in Mount Eliza, go right ahead.
Oh, good morning. Look, good morning, David. My question is regarding the laws of adverse possession. I'm wondering whether it's possible to claim a slither of land that runs along the side of the title of our property, but the land is actually roadway. It's not a laneway. It's down the side boundary, which is side road along the side of the property.
About 20 years ago, they changed the law, Peter, so that time doesn't run against a council or a statutory authority. So if it's always belonged...
Right.
Sorry, the nature of an adverse possession claim is that the other person loses the right to exercise the rights of owner.
Right.
So if it's a laneway, so there are hundreds of lanes around Melbourne that are vested in councils. They belong to the council and you have no rights of adverse possession. The same will apply to roads.
Okay, so the 30-year rule doesn't apply. Although I fenced off this land more than 30 years ago, we've been in the property about 35 years, and substantial trees are growing in the section, and it's not accessible from the road. It's still I have no claim over it.
No, but you might be able to buy it from council.
Oh, okay. I never thought of that. So I'd have to approach the council.
You'd have to approach the council and say, I've had this fenced for 30 years. I'd like to buy your rights in the land.
Okay, and they'll just come up with a sum?
And or they'll say no, one or the other.
Yeah, okay. Well,
but that doesn't mean that they'll necessarily require the fence to be pulled down.
That might draw attention to the fence, though, mightn't it?
Yes, it probably will.
Yeah.
Oh, yeah, well, actually, that's a point. Okay, thanks very much. I appreciate it.
Peter suddenly wants to duck underneath the radar there
I would
and
too.
not talk about these things anymore. Great to have you on board this morning, David. Thanks so much. We'll see you next week. David Whiting there, who's incredibly generous with his time.